How has contract law evolved over history? Imagine a world where deals were made with just a handshake or a simple nod. Over thousands of years, contract law has grown into a detailed system that protects everyone involved in business. It all started in ancient civilizations like Mesopotamia, over 4,000 years ago, where people began writing down agreements instead of just promising orally. These early contracts were basic, often about trading goods or land, and relied on community customs for enforcement. The Greeks and Romans added more structure, creating specific types of contracts like stipulations and formal written agreements. Roman law introduced ideas like secured loans and pledges, which are still part of modern contracts today. During the medieval period, contract law became more formal in Europe. Courts began to develop rules for private agreements, especially for land and serious crimes. The Court of Chancery started to ensure fairness in contracts, and contracts under seal, meaning they were written and stamped, became common for big deals. As trade grew, merchants created their own courts and customs to handle disputes quickly and flexibly. These merchant courts influenced the development of contract law by focusing on practical solutions for business needs. The industrial and commercial revolutions from the 16th to the 19th centuries pushed contract law further. Businesses started forming partnerships, joint ventures, and international trade agreements. The scale of business grew, so contracts became more detailed and standardized. New technology like postal systems and typewriters made communication and documentation easier, reducing errors and misunderstandings. This era saw the rise of complex contracts that needed clear terms about costs, timelines, and obligations. In the 20th century, countries began to write down and organize their contract laws into codes. This made the rules clearer and easier to follow. Landmark court cases refined how contracts are interpreted, emphasizing what reasonable people would expect. As multinational companies emerged, contracts needed to cover cross-border issues, and legal systems had to work together. The digital age brought new tools for drafting, storing, and managing contracts, making the process faster and more accurate. Looking at all these changes, it's clear that understanding this history helps us avoid common mistakes today. For example, early contracts often failed because they lacked clarity or formal details. Now, contracts should clearly state what each party will do, when, and how. Written agreements are preferred because they reduce misunderstandings and serve as proof if disputes happen. As business relationships became more complex, contracts needed to be tailored to specific industries and transactions. Ignoring fundamental legal principles like offer, acceptance, and consideration can lead to invalid or unenforceable agreements. With international trade, it's important to consider different legal systems and customs to prevent enforcement issues. Modern contract management tools help us draft, review, and store documents accurately, reducing human errors. By learning from the past, we see that clear, well-documented, and properly managed contracts are the best way to avoid legal mistakes and keep business running smoothly.